I have directed my bailiff to take all cell phones or recording equipment. I do not wish anyone to make
don't have a cell phone. No.
unauthorized presentation or video of this proceeding. You will get your phones back at the conclusion of the hearing.
No, I don't. I left it in the car.
Is there anybody else that are authorized to come in that's still waiting to come up?
No, these two gentlemen in the front row, the last two, Your Honor.
Okay. Well, there's some folks, there is some community interest in this case, and I can understand that. I did see that there's like 3 or 4 people who had logged on to my WebEx meeting room, but unfortunately, we are in person here today, and I'm glad to hear and see that it's nice to have people in the courtroom again. I'll be quite honest with you. We have, in the 22nd Circuit, we just returned to Phase 2. We just had our first jury trial last week, so things are eking toward being normal. So I do like having people in the courtroom versus on WebEx. So I'm glad we are here. And so we'll be on the record at this time. Ladies and gentlemen, we are here. This is a case from the 21st Circuit. Style of the case is State of Missouri, plaintiff versus Angela Freiner, the defendant. Cause number is 21SL-CR00998. I am temporarily sitting in Division 40 in St. Louis County, but of course we do know we're currently physically seated in Division 31 of the 22nd Circuit. I have been appointed based upon the fact that St. Louis County has recused itself on this case. I've been appointed to handle this matter from the Missouri Supreme Court. So I'm glad to see everyone is here today. And just to make sure that it is a little bit difficult speaking through masks and things, so I'm going to ask each of the attorneys to announce their appearance on behalf of your respective parties. So first, for the state of Missouri, if you would please stand and announce your appearance, please.
Justin Navy on behalf of the state.
Nicole Frankenberg, also on behalf of the state. Nicole on behalf of Angela Freiner.
Thank you very much. And for the record, Ms. Freiner is present today. And the court has scheduled this afternoon for the court to hear the plaintiff's motion for bond reconsideration. And so at this time, who wishes to present for the state of Missouri?
I will, Your Honor.
Very well. You may proceed, Ms. Nagy.
Would you like me to sit here?
Wherever you're comfortable. I'm not, in this day and age, in light of everything that's going on, the proximity to my, if you wish to remain seated, that is fine.
Okay. Thank you, Your Honor. As stated in the state's motion, we've been informed of further evidence highlighting the dangerousness of the defendant to the crime victim. When the officers approached the defendant after arrest on the active warrants, they observed her remove a bag she was carrying and
I need you to speak louder.
louder and slower. Okay. When the police officers approached the defendant to arrest on the active warrants, they observed her remove a bag that she was carrying and hand it to a male standing next to her. Inside of that bag contained a black Taurus firearm with bullets in the magazine, marijuana, and drug paraphernalia. The new information documents true and tangible threat to the safety of the victim in this case. We were previously provided this information by individuals involved in the investigation. However, I did not announce this to the court during the bond hearing until I obtained the police report or had contact with the police officer, because I don't want to accurately provide any information or speculation to the court. Now that we have this information, we find that this new information is extremely relevant due to the nature of this case. Whether or not the gun was legally obtained having a defendant who has consistently threatened and harassed a judge or any individual to the extent these charges and warrant was issued, and having her found with a functional deadly weapon is an extremely relevant factor that should be considered when determining whether or not that individual should be on bond, and whether or not that individual is a danger to the community and victim at large. For these reasons, I believe Ms. Briner is an imminent danger to the victim in this case and surrounding community.
Well,
The
thank
state
you.
has-
And the state has read the court has read the state's motion to reconsider and reinstate the bond. And I did receive a courtesy mailing today by Ms. Kalu as far as the defendant's response, and I have read that. At this time, Ms. Kalu, do you wish to respond to the state's position?
Yes, Your Honor. As we discussed at the previous hearing, Your Honor, my client was involved in family court proceedings with the alleged father of her daughter, Mr. Judy. Mr. Judy is a criminal who has been convicted of domestic violence in the state of Montana. When my client was pregnant,
Your Honor, I'm going to object again, as stated in the previous bond hearing, to any of the underlying facts of the paternity case or the sealed record, or anything having to do with this individual that she's speaking of in their criminal history, and to leave it to the facts alleged for the 30.09 bond hearing.
Your Honor.
Very well. Ms. Kalu, do you wish to respond to the objection?
Yes, I do.
How is this relevant, please?
It's very relevant because Mr. Judy suffocated my client on one occasion, broke her nose on another occasion, and broke her wrist on a third occasion.
Ma'am, I did read your memo. That was contained in there.
Right.
But at this time, I'm asking, how is that relevant to the court's Rule 3301 hearing and considerations?
Ms. Navy in her presentation makes it sound like my client is a criminal who is running around with a gun trying to shoot innocent people. She was carrying a gun to protect her own safety, which was legally purchased,
Okay.
and which was allowed by the
Okay,
Second
Ms.
Amendment.
Mr. Luke, I will sustain the objection by the state at this time. I would like for us to focus upon what is before the court, and that is relative to the state's motion to reconsider the bond. And so the court previously did make a ruling. There is new evidence before the court concerning the weapon. If you wish to address the factors in Rule 3301, I would invite you to do so. So you may continue.
At the time of the arrest, the state seized the weapon. So my client no longer has the weapon. The weapon has never been used before. It was brand new, and it remains brand new. When my client was released from jail, the weapon was not released to her. My client does not plan on purchasing a new weapon or possessing any weapon whatsoever or approaching the complaining witness. And
If I could interrupt one thing. Does the state agree with the statement that the weapon is still in possession of the law enforcement, the police department, or some entity with the state of Missouri?
Yes, Your Honor.
Very well. But go ahead.
I also understand that the court might have a problem with my client using marijuana and having drug paraphernalia at the time of the arrest. For that matter, she has a prescription, and I am happy to provide it to you, Your Honor, to review on camera, that the medication was legitimately described and purchased, and my client has a license for it. I also would like to put on the record that at the previous bond hearing, Ms. Maggie stated that my client was behind in rent. There was quarters in her apartment, and she was going to become homeless. Since then, I have done my investigation. My client is not behind in her rent. there are no issues with her landlord, and I have a full accounting of all the payments made. But, nevertheless, if the landlord decides to evict my client for whatever reason, we have secured alternative housing. Since my client was released on bond last week, she complied with the court order. She signed up with the remote control. She resumed her gainful employment, and she's been taking care of herself and her health. She got sick in jail, and she's not feeling well today, but she's still trying to be gainfully employed. When it comes to the argument under the Rule 3301B, the defendant is charged with a bailable offense. The defendant should be released from custody unless it can be shown by clear and convincing evidence that no combination of non-monetary conditions shall secure the safety of the community or any other person. In the present case, since the state has the custody of the weapon, and my client has no plans of purchasing another weapon, or even remotely come close to the courthouse where the complaining witness is residing, there is no clear and convincing evidence that she should be detained on $75,000 cash only bond. The state did not present any fact that Angela poses danger to the community or to the complaining witness. Now, under Missouri Statute 0301, people are prohibited from carrying a concealed knife, a firearm, or any other weapon. If they are entering with this concealed weapon in a restricted area, my client was arrested at her own home. She was not arrested in a restricted area where carrying weapons was prohibited. Her firearm was in her bag. It was not readily accessible. It was never used before. And when she was arrested, she surrendered the gun to the state of Missouri. When she left jail last week, she did not ask for her gun. Based on the United States Constitution and the Constitution of the State of Missouri and the due process clauses that afforded to all citizens in this country and in this state, $75,000 cash only bond is really unconstitutional for someone who does not have a criminal record, who has been always gainfully employed, who cares about her child, and does not present any danger to anyone. My client, under the law, is presumed innocent until the jury finds that she is not. So, therefore, I'm asking the court to release her on her own recognizance and deny the state's motion to reconsider her bond.
Well, does the state wish to respond?
No, Your Honor.
So, before I enter an order in this matter, I just want to make sure that there are some facts here that I understand now. That there was a weapon seized from the defendant in her own home when she was arrested. Is that correct? And that the state remains in control of that weapon and it has not been returned to the defendant. Is that correct?
Of that specific weapon, yes, Your Honor.
And the state requested the court to have Ms. Freiner register with the pretrial services for remote.com. And to your knowledge, she has done so. Is that correct?
No, Your Honor. I have no knowledge that she has. I have not been provided any information I've requested from Ms. Toulouse, and we've not been given anything in regards to that.
You may.
I'm happy to provide the information. I don't have it with me. I just assumed when you registered the state knows.
Oh, that's fine. I just want to make sure that she has registered, and as long as that is done, that's fine.
Yeah. And Your Honor, just to clarify, she was at her house when she was arrested, but she was outside of her house walking to her car with a bag. She wasn't inside of her home when she was arrested with a weapon on her.
Very well. So then I assume by both parties in this matter has been fully presented, been argued when it is given to the court. Is that correct?
Yes. Yes, Your Honor.
Very well. The court will entertain the state's motion to reconsider the court's previous order. And the situation basically is as follows. The court has and continues to believe that the previous order of this court is appropriate. The defendant shall be on her own recognizance. She'll have no direct or indirect contact with any state's witness. I will impose additional conditions of her bond, which will be that she remain 100 feet away from Judge Zellweger. And another condition will be that she will not possess a firearm nor be in the vicinity of a firearm. And that the weapon seized from the defendant shall remain with law enforcement until further order of the court. And so that is going to be the order of the court today, that she will remain on her own personal recognizance as long as she complies with the conditions of her bond. So with that being stated, I understand this matter has been scheduled for a preliminary hearing on April the 5th of this year. And Ms. Pillou, I do understand that you did request a continuance off that date. Is that correct?
Yes, Your Honor.
I see no reason why we cannot address that matter today. Is there a date that council can agree upon that we will continue this matter till a date specific in the future for a preliminary hearing?
I'm fine with addressing a preliminary date at this time. I'm not sure how long this will need.
I would be amenable to any day in May.
We were fine with that, Your Honor.
Forgive me, I do not know, is St. Louis County still in phase one?
I believe we moved to phase 2.
Phase two?
As of today.
I'm going to look at my week of May 24, and I would ask council to look at your weeks to see if you have any exclusionary dates for the week. I do have a jury trial that's scheduled for Monday of that week. But I was going to find it should be a priority case. Perhaps we could schedule this that Friday, so is Friday that week available for council?
What week again? I'm sorry, Your Honor.
That would be the week of May 24, so it would be May 28.
We are available, Your Honor.
Yeah, me too, Your Honor.
So if we could schedule this May 28 at 9 a.m. for a preliminary hearing. I might have to amend the location of that. I will contact the authorities in St. Louis County to see which courtroom might be available for us. Barring, if they don't have a courtroom, we have this one we could use. But I will say that on that date, we will have a preliminary hearing, perhaps. And we will have it in this courtroom. However, if I find that there is a courtroom available in St. Louis County, then please make note that I may amend this order to include the new location of the court hearing on the 28th of May. Is there anything else by any party?
Nothing you have to say, Your Honor.
Sure. I hate to say this, but since the pandemic struck, the court has been obligated to write all the memos, at least in St. Louis City. So I guess I'll get the luxury of writing the memo because I didn't sign it to anybody here. So I'll write the memo. Why don't you wait around and sign off on it to make sure I wrote it down correctly?
Thank you, Your Honor.
Sure. We'll be adjourned at this time. You may return all the telephones to all the folks. We'll be in brief recess. I'll bring up the number shortly.
Yeah,